Okay, good afternoon again. I'm going to make a short presentation on the international standards and their interpretation in the WTO agreement. Because this issue has become quite relevant in recent times, we have got two cases. One is a case involving India, that is India Agriculture Products case, very popularly called as the avian influenza matter. And we also have a very recent case involving a European Union, Latvia, Lithuania, and Russia, which is called the Russia pigs case. So these are two important cases in the area of sanitary and phytosanitary measures agreement. So I just want to actually talk about the sanitary and phytosanitary measures agreement to an extent. So till now we have been talking about financial regulation. So this particular area of WTO law is actually talking about health and safety regulation, or you can say food safety regulation to an extent. So in the WTO, every country has the right, the sovereign right, to protect human, animal, plant life or health, or to fulfill legitimate objectives at levels they consider appropriate. And this is something called the acceptable level of risk in WTO. So it is actually up to the WTO member to design or to calibrate the kind of risk they would like to protect against. So that option is available to a WTO member. So when you talk about the SPS agreement, it is called the Sanitary and Phytosanitary Measures Agreement. In very simple terms, the objective of the agreement is actually to protect the consumers within a particular country, or maybe animals and plant life in a country, from any kind of alien diseases. So think about a case, like the hormones case, or if you look at the salmon case, or maybe recently this kind of the African swine flu case. The importing country may have certain kind of reservations or concerns, saying that a foreign disease may come to their country and actually spread in a manner that cannot be controlled. So when you talk about the SPS measures, the basic protection of is actually at the entry, establishment, and spread of pest. Then the risk may actually come from a disease-causing organisms. It may also arise out of an additive, contaminants, toxins, organisms in food, beverages. Then it can also be, diseases which are actually called zoonotics, the disease that can be transmitted from one animal to another. So the very objective of the SPS agreement is to enable a WTO member to take measures which may be required, which may be necessary in order to protect against these kind of diseases may be coming into the country. So now let me talk a bit about the avian influenza case. This is actually a very good case. I was very privileged to be part of this particular dispute before the panel and later the appellate body. So when you come to the basic facts of the case, it is actually an import measure. So an import measure in the sense that India said that, we don't have this kind of a low pathogenic notifiable avian influenza in the country. But if you look at India, India is actually in the migratory pathway of bird flu or avian influenza. Mainly in the northeastern corridor of India, the birds actually spread this disease. And if you look at even the facts at the moment, the Delhi Zoo is actually closed because of bird flu. So it happens in various parts of the country, but those diseases actually arise out of what is called as a high pathogenic avian influenza. It is a highly virulent form of virus, and whenever this kind of a disease or bird death is actually noticed in any part of country, then India has got an obligation to notify the occurrence of the disease to an organization called the World Organization of Animal Health, or in other terms, OIE. It is based in Paris. So what has India taken in this case? India has imposed an import ban against poultry products coming from the United States. And this is actually a countrywide ban. So think about a situation if there is an occurrence of avian influenza in Tennessee, then India has a countrywide ban against the whole of the United States. And India's, if you look at India's acceptable level of risk, it is fairly high, because India's acceptable level of risk can actually be equated to some kind of a zero risk. India says that in the case of low pathogenic notifiable avian influenza, there is no concrete scientific evidence on the spread of disease from poultry to poultry or even from poultry to human beings. But at the same time, there have been some deaths in countries including China, so the science is to an extent uncertain. But India wants to take care against any kind of a scientific uncertainty, so India has come up with the extreme measure, and that is actually a ban on the product concerned. And this measure is again, taken only with respect to poultry products, and the measure was taken under the 1898 Livestock Act in India. So I just mentioned about this, the avian influenza thing. It's a very interesting thing because in India we actually see birds dying, sometimes the poultry population dying in various parts of the country. But these are all cases of what they call as high pathogenic avian influenza. But according to India's argument, the low pathogenic avian influenza doesn't exist in the country. And the United States, on the other hand, said that very much exists in India, but you have got very poor surveillance system. And that is the only reason you are unable to find out the occurrences of low pathogenic avian influenza in the country. And they said that this particular measure that India has actually taken is disproportionate. It is not actually calibrated to cover the risk that India is afraid of. So that is actually the argument taken up by the United States. So while coming back to the facts of the case, in the case of the SPS agreement, we know that the whole of the agreement is actually based upon science. So science lies at the heart of the SPS agreement. So in most of the cases, a WTO member imposing an SPS measure will have to conduct a risk assessment. And if that country is not in a position to take a risk assessment, it may have to depend upon the scientific practices, principles, testing, sampling, and other procedural methods taken up by other international organizations, or in certain cases by other WTO members in question. Those requirements are actually spelled out in Article 5.1 and 5.2 of the SPS agreement. But when coming to this particular dispute, the argument is that India hasn't actually taken a risk assessment. So risk assessment, according to the WTO, is a very systematic, it is a very organized procedure. So you can't actually come out with one report and say that, okay, this is a risk assessment. So in the case of India, there is something very interesting because there has been a risk assessment, but later on it actually came out to be a plagiarized report. And that was based upon the risk assessment of New Zealand. So the panel ultimately said that India doesn't have a risk assessment. So India has actually lost that window of defending its SPS measure. So when a country doesn't conduct an SPS measure, then according to Article 2.2 of the SPS agreement, every SPS measure will have to be maintained based on scientific evidence and cannot be done without scientific principles. So that means without science, you can't have an SPS measure. But there is another provision within the SPS agreement called Article 3 that says if India's SPS measures are actually based upon international standards and if they conform to the international standards, then there is a presumption of consistency of India's SPS measures with the SPS agreement and with the GATT. So that is actually a presumption. So India's only opportunity to defend the measure is to claim that the measure is basically in conformity with the international standards. And in this particular case, the international standards are actually the standards or the terrestrial code prepared by the World Organization of Animal Health. So now, this is the simple issue that we are examining in this case. The only relevant issue in this case is, can India actually come out with a ban on poultry imports? If India's ban is actually consistent with the terrestrial code, then India's measures actually conform to the international standards. So the issue is that whether India can actually come up with a ban. And that is why it is an interpretative issue. So I'm going to talk about the issues in detail. So this is actually the meaning of the term based on and conforming to. So let me also tell you one thing. When the SPS agreement was actually drafted in the WTO, the members said that the measures will have to be based upon or conform to. But at that time, the meaning of the term based on or conform to was not actually very clear. So the term based upon basically means it is built upon or it is actually supported by this thing. On the other hand, conform to means a higher level of similarity. So if you look at my next chart, it has to be a mirror image actually. So this distinction, to my knowledge, might not have been deliberately created by the treaty interpreters. But at the same time, in the Canada case, in the EC hormones case, Canada actually made this point. But the appellate body said if the drafters actually used a particular language, then we can't assume that the language is accidental. It has a particular meaning. But the importance is that the WTO appellate body has actually created a gloss on the meaning of the term, what is conforming to. And that particular language has actually undone India in this particular case. So now let me go to the next important thing. If you look at the terrestrial code, it actually says countries can import only from notifiable avian influenza or low pathogenic notifiable avian influenza free countries or also from zones and compartments. Now I'm going to take you to the next slide actually. So this is the chapter heading of the terrestrial code. It says recommendations for importation from either a notifiable avian influenza or high pathogenic notifiable avian influenza free country, zone or compartment. India's argument is that since it actually talks about a free country, even if there is an occurrence of notifiable avian influenza in Tennessee in the United States, India can determine a level of risk which can be equated to zero risk. So India can actually have a country-wide ban against a particular country. So that is what India basically said in that particular dispute. And also look at Article 10.4.1, recommendations for importation from NAI free country, zone or compartment. So the natural inference is that India can have a country-wide ban. Let me also look at the next thing. So this is actually the crux of the dispute in a way. I mean, all of you can actually take a look at this particular line, this paragraph of the terrestrial code. It says, a member should not impose immediate bans on the trade in poultry commodities in response to a notification, then I'm leaving out the remaining things, of infection with HPAI or LPI virus in birds other than poultry, including wild birds. So India's interpretation is that this language is actually in negative terms. If there is an occurrence of avian influenza in wild birds, that cannot be a reason in order to impose a trade restrictive measure in a commercially traded category called poultry. So India's argument is that India actually used a contrary argument. India said that if notifiable avian influenza is actually seen or occurring in poultry, by an a contrary interpretation, India should be permitted to impose a ban on the product concerned. So this is actually a literal interpretation. Now I'm going to the real issue involved here. The real issue is that whether the terrestrial code actually envisages a ban. If the terrestrial code envisages a ban, then we can argue that India's measures are conforming to the terrestrial code. Then this matter came up before the panel and the appellate body. The panel actually directed the scientific experts in that matter in order to give their opinion. And the appellate body said that this is absolutely fine because there is a provision called 11.2 in the SPS agreement, and there is a similar provision in Article 13 of the Dispute Settlement Understanding, where the panels have got the discretionary authority in order to seek information from scientific experts or technical experts. India's argument is that this kind of a language, which I mentioned here, is not a matter of scientific or technical matter. It is a language, it is a text, or it is a terminology. If you look at any international agreement, international standard for that matter, it is all worded in English language text, or maybe in French or whatever. And it is very similar to a treaty. If you look at the terrestrial code for that matter, or if you look at the product-specific recommendations in Chapter 10 of the terrestrial code, it is very similar to a treaty. So India's argument, India actually appeared to argue before the panel that this should be considered to be a treaty. And if it is a treaty, the only method or the only way to define the meaning of the treaty is through the principles mentioned in the customary rules of international law. Then India said that this cannot be actually equated to a fact-finding because there is no fact to find in this particular case. This is only a matter of interpretative importance. So now, this is what actually, this is what the panel said in this matter. India's approach to allowing an importing country to choose as a condition of entry the NA free status of the exporting country and apply that condition on a country-wide basis runs contrary to Chapter 10.4. So when the panel found that particular thing, they said that India's measures are not actually conforming to, or India's measures are not a mirror image of the international standards, and therefore India did not have a defense to support this measure. So the interesting issue which I want to, something similar actually happened in the Russia pigs case. I'm going to skip on those things. So these are the real issues involved in this matter. How should the terrestrial code be interpreted? Is it actually a treaty? Or what is the status of the terrestrial code? The second issue is, then should it be based upon the VCLT? The appellate body actually said that you can have a mix of approaches. Sometimes you can actually take the elements of the international standard as a fact and then establish evidence and prove that particular thing. But India's argument is that it is nothing but a text. So if it is actually a text flowing from Article 3.1 and 3.2 of the SPS agreement, it has to be treated as the part of an international treaty or maybe as an adjunct to an international treaty, and the principles of VCLT will have to be applied. So I'm going to take, in the next 2 minutes, I'm going to touch upon these things. So when you talk about the Vienna Convention of the Law of Trade, just 2 minutes, can I take? So in the VCLT, if you look at the VCLT, it is a very comprehensive method of interpretation. It basically says that a treaty will have to be interpreted in good faith according to the text, context, object, and purpose. Then they have methods of identifying the additional context, which includes any other agreement or any other international instrument. Then it also provides methods like subsequent practice, subsequent agreement, any of the rules of international law. And in Article 32, they speak about the supplementary means of interpretation. Why these are actually important? So think about a situation where a country has come up with a terrestrial code. Another member of the OIAE may actually understand that particular language and may have a particular practice. So that can be proven as a subsequent practice, which may be useful in the interpretation of the treaty. So India's argument in that matter was that if at all there is any ambiguity, any doubt with respect to anything that is mentioned in the international treaty, international standard, you have to necessarily apply the Vienna Convention of the Law Treaty. The appellate body doesn't have the appellate body is actually ambivalent on this issue because they can see the argument, but they have some difficulty in treating this international standard as a treaty because it has not been specifically incorporated within the agreement. So another interesting issue is that the OIA code, is it actually a treaty? If you look at the definition of treaty in Article 2 of the Vienna Convention of the Law Treaty, any agreement that has been in a written form, and if it is entailed to have some kind of legal obligations, it can be a treaty. In the case of OIA, the government is actually represented by senior officials in the Department of Animal Husbandry. Maybe this particular treaty, this agreement may not be ratified by the Indian government, but it has got a lot of trappings of a treaty. So maybe the one argument that other countries should take up in the future is to say that these international standards are also treaties, and therefore they will have to be interpreted according to the Vienna Convention of the Law Treaties. That is one line of argument coming up. The second is, there is actually, the second is which my approach is that the whole thing should be treated as a context. But if you look at Article 3.1 and 3.2, the term is international standards, guidelines, or recommendations. It is possible to argue that these words are not by themselves ambiguous. So if you look at the WTO cases in the past, the WTO appellate body has actually spent nearly 30 pages in trying to find out what salted chicken cut is. One more minute, last minute, right? So the appellate body has actually spent so much of time in trying to understand what is discriminatory, what is sporting activity, what is actually arbitrary, what is unjustifiable. So if the appellate body is so keen on trying to find out the dictionary meaning of some of the words, when it comes to an international treaty, they should follow the same kind of an approach. So I'm just coming to the conclusion of this is what I have mentioned. Thank you.